Are you Randy Swisher?
Yes, sir.
All right. Case number 21 CR 88, State of Ohio versus Randy J. Swisher. This is Highland County Court of Common Pleas. Ms. Swisher, you were indicted by the grand jury along with Brett Swisher on May the 4th of this year on, looks like 4 charges. The first count is aggravated trafficking of methamphetamine. It alleges that on or about November 4, 2020 in this county, Brett Swisher and you normally sold, robbed, or sell methamphetamine in an amount over bulk amount, but less than 5 times bulk amount. And that is a third-degree felony. Count 2 alleges that you, on or about the same date, possessed that amount of methamphetamine. And that would be aggravated possession charge. Count 3 alleges aggravated trafficking of methamphetamine, the same as the first count, except it says it happened on November 9. And then count 4 is aggravated possession, same as on November 9, you had in your possession that amount. All 4 of these are third-degree felonies, which if convicted carry a possible prison term of between 9 and 36 months in different increments as provided by law. There's a fine of up to $10,000 and a possible license suspension of 6 months to 5 years. All right, now you are entitled to have an attorney in this matter, and if you cannot afford to hire one, will be appointed. I don't think I have a, do I have a financial disclosure form here, Ben?
I do not know, Judge.
I think I do. All right. You probably did not get a financial disclosure form to fill out, did you?
Yeah, I did. I returned it by mail.
Oh, okay. Well, I don't think we've received it yet, but make a note for that, and then if it's not there, I'll put one that says, I'll just sign and say that you can't do it since she's incarcerated. I assume you don't have any money to hire an attorney being incarcerated?
No, sir.
Okay, and you do wish to have counsel appointed for you?
Yes, sir.
All right. The court then will find that you are entitled to appointed counsel. Have you been in court on this charge before today?
No, sir.
All right. The court will appoint attorney Catherine Hafner of Hillsborough, Ohio, to represent you. And in the absence of counsel, I'll enter a not guilty plea on your behalf. All right. We will set a video pre-trial for you the week of September 1st. And time to be determined. It takes us about, we'll have to arrange these things out about 3 weeks in advance. We'll set a final pre-trial that'll be in person for September 22nd. And that'll be at 1 p.m. And then we'll set your trial date for October 12 at 8. I tell you what, I better make that October 14th. I think Ms. Hapner, some Monday she has to be in another county as a public defender, so that's a Thursday, and that'll be at 8 a.m. Now, what is your sentence that you're serving right now? How much time?
I get out on January 21st of 2024.
Okay, and what
3
county is
years.
that? What county is that from?
County,
What county?
Claremont.
Claremont. Okay, all right. Well, I'm going to put a bond here for $10,000. That's just in case for some reason you might be released prior to that, prior to the time you come to court on the 22nd or the 14th of October. So, and that would also include a requirement to pay the deposit of $171 for certain statutorily required fees prior to release. So if you were to be released, you would then, there'd be a holder on you and you'd be brought here to this jail for processing for bond until you're in main custody until you post the bond or completion of your case. All right, we will notify Ms. Hapner of her appointment, and what we'll do is we'll set that up by video where you will have a chance to talk with her before and by video, and then we'll do that pre-trial, and then you'll be conveyed down here for your final pre-trial and on the 22nd of September, and your trial, if necessary, on the 14th of October. Do you have any questions, Ms. Swisher?
No, sir.
Okay, all right, thank you. This is case number 19, CR 184, State of Ohio versus Donald L. Kenson. Here on behalf of the state is the Assistant Prosecuting Attorney Matt King. Here on behalf of the defendant is Attorney Catherine Hackner. And are you Donald L. McKenzie?
Sir, yes, sir.
All right, Mr. McKenzie entered plea of guilty to a bill of information on September 30, 2019. Matter was referred for pre-sentence investigation. The court did order that and set the sentencing hearing for November the 6th. Mr. McKenzie has been in federal custody since then, and the sentencing was not able to be conducted on the 6th of November since he could not get him removed from the federal custody. And so the matter was put on an inactive docket until the court could actively return for sentencing. On July 22nd, the court received a motion from the state indicating that the defendant had been released from federal custody, and we had had a $20,000 bond, so apparently that's ignored the holder, or perhaps it wasn't properly placed, I don't know. In any event, he was released from custody, and so when I received that, I ordered the motion, or I ordered the reform to have him brought into custody so we could proceed with the sentence. I did review the pre-sentence report, and the parties' counsel each had a copy of the summary. Is that correct, Mr. King?
Yes, sir.
Ms. Howard?
Yes, Your Honor.
All right. Mr. King, anything on behalf of the state?
We was contained the plea agreement, Your Honor.
Simon?
Thank you, Your Honor. Here, the plea agreement was for drug court and community control. Mr. McKenzie has been in federal custody for quite some time. He was furloughed from federal custody, and since the time of his furlough, he has completed an inpatient drug rehab. He initially started at Phoenix, then one of his at Phoenix. One of his co-defendants from his federal case also enrolled in that program, so he was then transferred to the Nova House. He completed that program on July the 10th, so less than a month ago, and he was involved in the aftercare program. So he's taken the steps to get himself back where he needs to be. He did interview with Ms. Sturgill prior to his removal to the federal custody for drug court, so I'm not sure exactly. He had his interview with her. I'm not sure where that process stands. His attorney in his federal case submitted his pre-sentence memorandum July 29th. His sentencing parameters in the federal case are 77 to 96 months. So he is facing significant time there. However, I believe that court may also be considering drug court for him. That's not my bailiwick, but that, according to Mr. McKenzie, that is, and according to the sentencing memorandum that was filed, that is what they are requesting in that court also. We do believe that drug court would be beneficial for Mr. McKenzie. He informs me that he's been holding, when he was not in custody, sober family gatherings at his home for sobriety, and they're keeping people sober and keeping them on pace, which we think is a good thing. So we would ask that you send him to drug court, and hopefully the federal courts will do the same.
Has he pled guilty in the federal court?
He has, Your Honor.
To what?
To one count of, hang on a second, I will tell you exactly what it was. Is conspiracy to possess with intent to distribute a controlled substance in violation of 21 U.S.C. 841.
Okay.
But the federal court has not yet set a sentencing date. They basically terminated all deadlines in that case. There's 127 defendants or something. So it's
okay. Mackenzie, anything you'd like to say?
Yes, sir. I would love to be able to show the courts that I have really took an effort to sit down and adjust myself and trying to better my way of living. And I have been throwing sober functions at the lake for people, and I got my CDCA. I've been trying to give back to the community as far as, the community's been coming back to me. I've been out for a year in the county, and I wasn't aware that I was supposed to contact the courts. I contacted my attorney, but never got no response, so I just was waiting until I was furloughed on the Fed, so I was just waiting to see what was going to come about there. I have been doing my aftercare at Icron in Cincinnati. I've been sober. I had a lapse in recovery, and I signed myself into the Phoenix Center. And then, like she said, my co-defendant was there, so I had to transfer to the Nova House, and I completed it. It's been about a month. I still have a job. I have employment. I have a sober support network. I would like to be able to participate in the drug court and show you in the courts and the community that I am willing to change, and I'm trying my best to get a handle on my disease and keep track of what I've been doing for the right thing for my kids.
Anything else?
No, Your Honor.
Well, I'm not aware of drug court program, what they do, but with the sentencing guidelines at the federal level, they have a certain parameters, and for the court to deviate down in that direction, be certain findings and different things, and I'm not aware that there would be a deviation down from 77 months, 6 months down to drug court in control, particularly for the type of charge, federal charges. Typically, the federal government doesn't invest that much time and resource in prosecution, and I believe that the indictment was completed with email or with Mr. Full include that in the material that he was presented to me. There's no report from Mr. Sturgill, but that's not his fault, certainly. But if it weren't for the complication of the federal case, then that would make it a little bit different. But I know that there have been some previous treatments that were successfully completed. They could always completed the treatment successfully, Mr. McKenzie, when things were involved. But I'm looking at this record that you have here. You have 8 prior convictions. I think maybe 3 or 4 numbers at least. And you have what appeared to me to be likely prison sentence in the federal court based on that. So I don't think that the drug court, certainly we can't have the drug court down with the federal government's sentence coming in. And I don't think there's any way that there's not going to be some sort of incarceration. But, I could be wrong about that. But, nonetheless, after reviewing the record, it's the judge or the court finding the defendant's not being in control, and so therefore the court could be sentenced to the Correctional Reception Center in Ohio for a period of 9 months. I don't think there is any recoveries in that from one time. Actually, there's 37 days of time credit, and that will be included in the entry. Upon completion of this, of course, I don't know whether we're going to get this sentence, the federal sentence first, I don't know what might happen. They remove you from the custody of the DRC for your sentencing. They may keep you, I don't know. And then you'll have to return to finish your sentence in prison. In any event, upon completion of that sentence, it is possible that the Adult Parole Authority may place you under post-release control for a period of 3 years. 3 years, they don't have to, but it's their choice, not the court. It has nothing to do with it. If they do, supervise under the parole term set by the parole authority by a parole officer, and if they determine that you have failed to comply with those conditions, they can return you to prison for an additional period of up to half of your prison term for one or more violations. But if you committed a felony while under post-release control supervision, then an additional letter sentence. The judge in new case can impose upon you. That judge is also authorized sentence, in this case, to an additional period of 1 year, whatever time left on that period of post-release control greater. That occurs that has to serve consecutively the sentence in the case. You also will pay the court costs of judge back execution order and fail to do that, then the court can order you to do police service once you've been released from prison, not while you're in prison. In this county, and we're giving credit for each hour you work, and in our website for each hour you work, reduce your judgment on that, not to pay. All right, anything further, counsel?
Chair, my client has informed me that he wishes to withdraw his plea.
Well, it's too late, it's consent, and there's no reason for him to withdraw the plea. He was made a passion pitch for community control, which was not successful, and see no reason to be allowed to withdraw the plea other than buyer's remorse, which is not a legal practice. So, denied. All right. Remand custody. All right, Madeline Arnett. Case number 20 CR 216, State of Ohio versus Madeline Arnett. President of the state, Assistant Prosecutor Kane, President of the defendant, Attorney Catherine Hafner. You are Madeline Arnett. All right, Arnett is charged with transferring evidence of third-degree felony. Let's see. This, we had a plea.
I think that's the wrong case, Your Honor.
Yeah, it is. That was close.
She's on treatment for.
Huh?
So that's the case she's on treatment with.
Yeah. Yeah, I don't know why. What case is the,
It's 21 CR 0036.
all right, thank you. We have a wrong hearing on this case on this Arnett. This one is closed. That was an intervention plea, so I don't know what case she's on, but it's not this one. I have the wrong case number then. What's the case number again?
21 CR 0036.
So we need to change the recording. 21 CR 0036. 20 CR 216 is closed. That was an intervention in lieu of conviction.
Okay, Judge.
And we're on the pause here because I don't have the file. Okay, 21 CR 0036, State of Ohio versus Madeline Arnett. As indicated, King is present on behalf of the state, and the defendant is represented by Catherine Hafner. And hold on, I'll just switch this one. And you are Madeline Arnett?
Yes.
All right, Ms. Arnett is charged with malicious assault and a forfeiture. This is a status conference, trial set for the 12th of August, and Ms. Hacker was out, last week, and, I think there was some other, issues that, led to the matter being set today. And I do have a request for a continuance, for the trial date, on this matter is, previously scheduled, hearing in Washington Courthouse, Municipal Court, in Fayette County. Juvenile court. And I know the court has, other cases going to trial that day, and sex offense, so the court will grant that motion. Continue. Now, before we get into that, is discovery complete in this case?
You can stay here.
It is, Your Honor, except that, Mr. King and I have been having some discussions which might lead to additional discovery.
Okay.
It might lead to resolution of the case, it might lead to additional discovery.
Okay. And there are no pretrial motions?
Not at this point in time.
All right. There's been a written plea offer.
There's been a written plea offer.
And your client's word.
Yes.
Okay.
And I believe the rejection was just executed also.
Yeah, I'm gonna go over that with her when we finish, because I need to discuss with her the other items that Mr. King and I have been discussing.
Okay. Okay. All right. Now, then what I'm going to do is I will set another pretrial, extend the pre-trial motion period. And then the trial date. Okay. So we will set a formal pre-trial. August 25th.
I was afraid you were gonna say that, Your Honor.
Okay.
I've got a 1 o'clock hearing in the Ross County Juvenile Court. I'm available
So what
that
time?
morning. That's at 1 o'clock.
I think we can probably do it in the morning.
Okay, I'm available in the morning.
August 25th in the morning. That's our first pre-trial date in August. Continue the trial date.
Right.
Okay. All right, 10 o'clock. Now, we need another trial date. We're gonna plan. Make one about that. Yeah. Yeah, I'm back. I think you said that earlier. Well, no, we'll be back. Yeah, I'll be back on let's see, the runs from Saturday to Saturday. I'm usually back on Sunday or even Saturday night, so that would be the 18th. So, what about the 21st of September?
I can't do the 21st. I'm available the 20th or the 23rd or the 11th.
And, Ms. Arnett, then you won't have to be here on the 12th, be here on the 25th, and then your trial will be this 20th of September, that happens. Dale's gonna give you an assignment notice, so you'll have your new dates, and you need to talk to your attorney here this morning about the plea offer rejection, and then, any other matters, and then, any event that there's something that comes up, this afternoon, you can get the motion filed, hopefully before the 25th, so we can get it set, in a hearing, that might be required if you file a pre-trial motion, so. Okay, anything, further?
No, Your Honor.
All right, thank you. Get your assignment notice there, this, all right, I thought I saw Mr. Wagner.
He's talking with Paul.
Okay. All right. Is he back?
He's out in the hallway.
No, he's out in the message board, he's by us. Say what now? All right, now, please. All right, Seth Wilkes. Yeah, come on up here and have a seat. Furnish your meeting here momentarily.
Your Honor.
Yes. All right, we have another file missing here. For 20 CR. We have 2192, but we don't have 20 CR 261. And check sheets in there, wasn't in the stack here. And I'll need to get it inserted up. Like if you got 5 minutes.
Yes, sir.
I'm gonna step off, just everybody stay seated. All right, we have two cases here involving the same defendant. Case number 20 CR 261, State High versus Seth Wells, and 21 CR 92, also State High versus Seth Wells. The state's represented by Assistant Prosecuting Attorney Adam King. That's represented by Attorney Jacob Wagner. Are you Seth Wilkes?
Yes, sir.
All right, in 20 CR 261, Mr. Wilkes has been indicted on aggravated possession of amphetamine and possession of drugs and three felonies. And in 21 CR 92, we've been indicted for failure to appear. Now, I've been presented with plea agreements in these two cases, Mr. Wilkes, which indicate that you're going to not guilty plea guilty to both cases.
I'm sorry. He's had a question on the degrees of the drug charges, Your Honor. It goes from 4 to 5.
I thought you said have 3 felonies on the 2 drug charges. I was confused there.
If I said that, I was wrong. They're both 53 felonies. I thought I said 53 felonies, but you know.
Right. Well, you scared me personally,
Well, it's certainly possible that I said that. So I apologize. I did. All right. So those are the 53 felonies, and then the failure to appear is 4. So.
Right.
Now, it indicates that you're going to withdraw your plea of guilty in case number 20 CR 261, plead guilty to the first count and to the charge as indicted in 21 CR 92. Each of these agreements are 3 pages long, Mr. Wilkes, and each of them have a sentence at the top, near the top of page 3, which says, I enter this plea voluntarily, and then below that there's signature line. And I'm looking at both of these, and this appears to be the signature of Seth Wilkes. And did you sign both of these agreements I'm looking at?
Yes, I did.
When did you do that?
This morning.
Okay. Did you go over these with your attorney before you signed them?
Yes.
And was that here at the courthouse or at the jail?
At the jail.
Right. And did he explain each of these to you, go over them with you so you understood what they were?
Yes, he did.
And you understood that signing these agreements, you're agreeing to plead guilty, which means it won't be a trial. In either case, the next step would be a sentencing.
Yes, sir.
And do you think you've had enough time to fully consider this matter before making this decision?
Yes, sir.
Are you entering into agreement to plead guilty in each of these cases voluntarily?
Yes, sir.
Right. Case number 20 CR 261, as I indicated, it says you're going to plead guilty to aggravated possession of methamphetamine, a violation of 2925.11, the Ohio Revised Code, a 5th-degree felony. And further states that you understand the maximum penalty for that could be 12 months in prison if a prison term is imposed, the minimum would be 6. And any found in between, there could be a fine of $2,500. There would also be a license suspension of 6 months to 5 years. Then in case number 21 CR 92, pleading guilty to failure to appear in the other case, violation section 2937.99 of the Revised Code, a 4th-degree felony. You understand that the maximum penalty for that, if prison term is imposed, to be 18 months. The minimum on that is also 6 months. There's a fine available of $5,000. Do you understand that?
Yes, sir.
And if you are convicted of both of these offenses and sentenced to prison for both of them, the sentences could be ordered to be served consecutively, meaning one after the other. So that means it's a total of 12 months and 18 months, which means there's a possible maximum term of 30 months and a total fine of up to $7,500. Do you understand that?
Yes, sir.
Now, are you facing any felony charges in any other jurisdiction?
I have possession, aggravated possession of drugs in Claremont County. Yes.
Is that a 5th-degree felony as well?
Yes.
Okay. And where does that case stand? Are you still awaiting trial on that?
Yes, I talked to Tanya Sturgill the other day, and I guess she's trying to get that taken care of. I'm not sure.
Well, the Sturgill can't get it taken care of.
Right.
She's not an attorney.
Right.
She
I don't
doesn't
know how it's
represent you.
working.
She would just be inquiring as to what's going on.
Right. I don't know how it's working.
Yeah, okay.
Yes,
You have an attorney out there.
Yes, I think I have my next
I
one.
looked it up a couple
down
days
there.
ago. I don't remember the date, but there's a BD appointed.
Okay.
But it's docketed.
But he's not been to court or anything yet,
No, it's through the
other than
arraignment.
the arraignment.
It's through the arraignment. I don't remember the jury trial date off the top of my head. I can look it up.
That's all right, not necessary. All right, the reason I asked that, Mr. Wilkes, if you're convicted of these two offenses and sentenced to prison, and if you're convicted of an offense in Claremont County sentenced to prison, then the Claremont County case could also be ordered to be served consecutive to the charge of sentences in these two cases. You understand that?
Yes, sir.
Okay. Other than that, any other charges?
No.
Are you currently on probation, community control, parole, or post-release control for a felony?
No.
Okay. Now, under the law, if you are convicted of these two offenses, and if you are sentenced to prison, once you complete that term, the law provides that the adult parole board has the discretion or option, if they want to use it, puts you under what's called post-release control supervision for a period of up to 3 years. They don't have to do it, but it's up to them. The court has no involvement in that. If they decide to do that, you'll be supervised on the terms they set for a period of up to 3 years by a parole officer, and if they determine that you have failed to comply, they have the right to return you to prison, even though you served the entire term set by the court, up to 9 months for a single violation, but there is a cap or limit, a path of whatever prison term you serve as ordered by the judge for one or more violations. If you commit a new felony while under post-release control supervision, then in addition to whatever sentence the judge in that new case to impose upon you, that judge could also sentence you for committing that violation while under post-release control supervision in these two cases to an additional period of 1 year, or whatever time's left on that 3 years of post-release control, whichever is greater. And if that occurred, that would have to be served consecutively to the sentence in the new case. You understand that?
Yes, sir.
All right, now, under the law, I'm not required to sentence you to prison for either of these offenses. I could impose what's called community control. And what that means is that instead of going to prison, you'd be put under the supervision of a probation officer for a period of up to 5 years under the term set by this court. If during that period of time that you were being supervised, the probation department felt that you had failed to comply, they would have to file a written notice of that with the court. There would be a hearing, and you'd be entitled to have an attorney to represent you at that. If the outcome of that hearing was that you had failed to comply, then at that time, the court could revoke your community control in these two cases and then sentence you to 12 months prison, fine you $2,500 in the 20 CR 261 case, and sentence you to 18 months and fine you $5,000 in the 21 CR 92 case, consecutively for a total of 30 months and fine of $7,500. Do you understand that?
Yes, sir.
Right now, the charge in case number 20 CR 261 in count 1 reads that on or about June 7, 2020 in Highland County, Ohio, you did knowingly obtain, possess, or use Schedule 2 controlled substance with methamphetamine in violation of Section 2925.11 of the Ohio Revised Code. And then in the 21 CR 92 case, it alleges that on or about March 31, 2021 in this county, you recklessly failed to appear as required in Highland County Common Police Court, case number 20 CR 261, after having been released pursuant to ORC 2937.29 and released in connection with the charge of commission of felony in violation of Section 2937.99 of the Revised Code. So that's the failure to appear charge. And the other one of other cases, the aggravated possession of methamphetamine charge. Now, Mr. Wilkes, do you understand what the state is accusing you of having done in those two charges, what they said you did, what, where, and how they alleged you did it?
Yes, sir.
Do you understand the possible penalty for each offense?
Yes, sir.
Now, have you discussed the nature of those charges, the evidence in the case, the possible legal issues in the case, the possible defense you might try to raise in trial, and possible outcomes of the trial with your attorney?
Yes.
Are you satisfied with his advice and confidence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Are you taking any prescription drugs?
No.
Have any threats been made against you to plead guilty here today?
No, sir.
Now, on about halfway down on the second page of each, there are some printing and bold and underline that contain the primary terms of this agreement. And in 20 CR 261, it says defendant shall enter pleas guilty to count 1, state will dismiss count 2, state defense will already be sentenced. In 21 CR 92, says defendant shall enter plead guilty to the indictment, state defense will already be sentenced. Has anyone promised you anything other than what I just read to you in those two agreements gets you to plead guilty in either case?
No, sir.
So you've not been told if you plead guilty you're going to get a particular sentence?
No, sir.
Okay. You hold any license or certificate from any state agency from any kind of an occupation or profession. You know, like nurse's aide or, anything like that. Teaching assistant, counselor, etc.
Carpenter, master carpenter.
Yeah, but that's a union certification or trade association. Nothing from the state. Okay. Right now, you have certain constitutional rights you must understand before I can accept your plea of guilty in these two cases. And so what I'm going to explain to you applies to both cases, whether I mention it or if I say it doesn't matter. In each case, you have the right to have counsel. Mr. Wagner was appointed to represent you in each case, and that wasn't simply working out the case or cases, but to provide any defense that might be available to you under the law in either case that you wish to present. And so, if you decide you do not want to plead guilty, he will continue to represent you. He'll defend you in both of these cases, including going to trial if that's what you want to do in either or both cases. You understand that?
Yes, sir.
In the Constitution, you have a right to have a jury trial in these two cases, in which 12 people would be selected from a group of citizens that live in this county who are summoned for jury duty on your trial day. After they are 12 of those will be selected. After those 12 are selected, they will hear the evidence and be instructed on the law. And then that jury would have to decide in each case by unanimous verdict, meaning all 12 have to agree on a verdict in each case, whether or not to stay true that charge in that case against you. If you decided you didn't want to have jury trial, but you didn't want to plead guilty, you can waive in writing, which means give up your right to have a jury trial in each case, and or either or both out. That'd be up to you. And if you did that, then you would have what's called a court or bench trial, meaning that instead of the jury hearing the evidence in that case, or cases, it would be the judge who would hear the evidence, apply the law, and decide whether or not to say proof or guilt by proof beyond reasonable doubt. Do you understand that?
Yes, sir.
And in each case, you have a right to confront the witnesses against you and to cross-examine them through your attorney. So if what that means is that witnesses against you have to come in and testify in front of you and your attorney and anyone else that might be present in the courtroom. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that would be to bring out evidence that will help your side of the case in each of those two charges. You understand that?
Yes, sir.
Right now, under the Constitution, in each case, you have a right to use the power of this court to compel or force witnesses to come to court to testify for you, just like the state. So if you have witnesses you're uncertain are going to come in voluntarily, at your request, the court issues a court order called a subpoena in that particular case or cases. And that will force those witnesses in that case to come to court and be available to testify if you wanted them to, even though they did not want to be involved or be present, which is the same way that the state's witnesses would be required to come to court to testify against you in each case. Do you understand that?
Yes, sir.
Under the Constitution, in each of these cases, you have a privilege against self-incrimination. So what that means is that you're not required, that you cannot be required to give evidence or to testify against yourself at any time in either case, including trial. So, no one can ever make you testify. The prosecutor can't, the judge can't. You make that decision. And if you decide not to testify, the fact that you did not testify will not be used against you in any way by any person. No one's even allowed to comment about it except in one situation, and that is if there's a jury trial and you don't testify. The judge does instruct the jury that because that is your right, they cannot consider it for any purpose. You understand that?
Yes, sir.
Right, under the Constitution, in each of these cases, you are presumed innocent until proved guilty by the state on every essential element of the offense charged. What that means is the burden of proof is on you to try to show you're not guilty of these charges simply because you've been indicted in each case by the grand jury. In fact, under the law, you don't have to present any evidence in your own defense at the trial in any case. You could, but you're not required to. Whether you present any evidence in your defense at trial of these cases or not, the burden will still remain upon the state of Ohio to prove your guilt in each case by proof beyond reasonable doubt on every element, essential element of each charge, which is the highest burden of proof that's known under the law. You understand that?
Yes, sir.
Right now, in each of these cases, Mr. Welch entered a not guilty plea, which denied the allegation in that particular charge and denied that you committed any crime. That plea exercised or revoked all the rights that I just described for you here this morning. If you change your plea from not guilty to guilty in these two cases, That's the opposite of a not guilty plea. The guilty plea admits the allegation in the indictment, admits that they constitute a crime, and that you're the one who committed that crime. In that plea, the wage gives up any right to file an appeal that you think you may have had up until this point in the case. Now, if I were to sentence you to the maximum sentence, or in either case, or under other certain circumstances, which are limited, you could file an appeal, but that would have to be filed within 30 days of your sentencing entry being filed. It also subjects you to being sentenced immediately by the court, if that's what the court decides to do. Now, do you understand all of that?
Yes, sir.
And are you a U.S. citizen, Mr. Wilkes?
Yes, sir.
Now, do you have any questions then about either of the charges or the possible penalties?
No.
You understand?
Yes, sir.
Any questions about the plea agreement?
Yes, sir.
You understand?
Yes, sir.
Again, you understand that there's no recommendation, so it could be that you'll be sentenced to prison in this case. Of course, even if there was a recommendation, it's up to the judge to make that decision. You understand?
Yes, sir.
Okay. Any questions about any constitutional rights I've explained? You understand that?
Yes.
You have any questions about the plea of guilty, what it means, what the consequences of that will be in either of these cases that we enter here today? You understand?
Yes.
Any other questions you'd like to ask Mr. Wagner before we go any further?
No.
Have any questions about anything I've explained to you here this morning?
No, sir.
Mr. Wilkes, it's your decision to withdraw your not guilty plea and plead guilty to count 1 and 20 CR 261 and to the charge and the indictment of 21 CR 92, subject to plea agreements that we've just gone over. Is that your decision?
Yes, sir.
Okay. Then as to count 1, in 20 CR 261, which alleges that on or about June 7, 2020, Huntington County, Ohio, you did knowingly obtain, possess, or use Schedule 2 controlled substance with methamphetamine in violation of Section 2925.11, Ohio Revised Code, a 5th-degree felony carrying possible prison term if convicted between 6 to 12 months, fined up to $2,500, and possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
Right. In case number 21 CR 92, that alleges that on or about March 31, 2021 in this county, you recklessly failed to appear as required in Huntington County Common Pleas Court, case number 20 CR 261, after having been released pursuant to ORC section 2937.29, released in connection with the charge of commission of felony, violation of section 2937.99, the charge of failure to appear, and possible prison term between 6 and 18 months, and fine of $5,000. How do you plead?
Guilty.
Thank you. You see. All right, the court finds that on this day in open court, the defendant was advised of all his constitutional rights, made a knowing, intelligent, and voluntary waiver saying, pursuant to Rule 11, these are set before the accountability of count 1 of 20 CR 261 as charged, count 2 dismissed, found guilty of failure to appear, and as charged in the sole count of the 21 CR 92. Court will order a pre-sentence investigation. Bond will be continued. And the court will order the assessment be made as to possible treatment for substance use disorder and mental health. Are you requesting the drug court?
We've already started the process, Your Honor.
Needs to be referred to drug court for evaluation. Mrs. Sturge will be in touch with you and determine if that's something that you're interested in. It's not mandatory. The court doesn't sentence people that they accept people. So she'll explain to you what's required, and if you are admitted in that program, then give me your assessment as to whether you meet the criteria as far as treatment is concerned, and then I'll make a decision. Final decision whether or not it's appropriate to be put into that program. Bond will be continued. We'll set the sentencing hearing in each case for September 1 at 9 a.m.
Yes, sir.
Thank you.
Thank you, Your Honor.
All right, just have it back to the back there. Whoops. Garrison Salyer,
Right, Your Honor.
May. Case number 21 CR 93. State of Ohio versus Garrison Michael Salyer. Present for the state, Assistant Prosecuting Attorney Adam King. Present for the defendant's attorney Jacob Wagner. Are you Garrison Michael Salyer?
Yes, sir.
Mr. Salyer is charged with 2 counts of rape, first-degree felonies. The matter, I believe, is set for a hearing on a motion to dismiss or suppress, or eliminate, and that is actually set for tomorrow at 1:15. I think the trial set maybe in August, sometime later this month.
23rd, I believe.
The defendant and state attorneys indicated that there had been an agreement reached in this matter, and so the matter was set today at the request of the parties for a plea hearing. And I see that we have a plea form here. Which is a 4-page document in this case. That's been prepared by the state, and it indicates you're going to plead guilty to a charge of rape, count 1 under 2907.02A2, currently charged under 2907.02A1, which would then require a bill of information to be filed, and I've also been presented with that, along with a waiver of prosecution by indictment. So, first of all, Mr. Salyer, on page 3 of this form, there are signature lines. About halfway down the page, there's a sentence that says, "I enter this plea voluntarily," and then I see a signature that appears to be Garrison Salyer. And is that your signature I'm looking at?
Yes, sir.
And when did you sign this agreement?
I have to say about 2 weeks ago.
About 2 weeks ago? All right. And did you go over this with your attorney before you signed it?
Yes, sir.
And he was present when you signed it?
Yes, sir.
He explained everything to you and answered your questions?
Yes, sir.
And you understood then that it was an agreement to plead guilty, which means there's not going to be a trial, and the next step would be a sentencing hearing?
Yes, sir.
And I know you signed this a couple of weeks ago. I've talked with Mr. Wagner about it since then.
Yes, sir.
And is this still what you want to do?
Yes, sir.
Are you entering into this agreement to plead guilty voluntarily?
Yes, sir.
All right. Now, in the case as charged, there's 2 counts, both under 290702A1B. Those are first-degree felonies, which I believe carry a sentence of between 10 to life, 25 to life, and life without parole. Is that correct, Mr. King?
There'd be 15 life.
Or 15 to life, not 10. Okay, 15. Okay. Now, it's being proposed that instead of that, you plead guilty to a different charge under rape under the second section of A, 2907.02A2. And that basically is written so that it changes, it doesn't address the issue of age of the alleged victim. And that would be a first-degree felony, which would have a maximum prison term of 11 years. The minimum would be 3 years, and it's mandatory. Whatever sentence is imposed has to be served. So there cannot be any judicial release or any reduction in the sentence. You have kind of credit, but you won't get any reduction on the original sentence, whatever that might be. Now, that sentence, that 3 to 11 years, is a minimum sentence that is imposed by the judge. And Under the laws that affects this particular case, called the Reagan Coach Law, the Department of Rehabilitation and Corrections, DRC, has the authority to decide whether or not you should be required to serve more than that. And if they decide to do that, they could actually make you serve up to half whatever prison term the court would. So if you receive the 11-year maximum, then they could make you serve an additional 5.5 years, which would be half of 11. So that means the maximum prison term could be 16.5 years. If it were the minimum of 3 years, then that would make it 4.5, because 1.5 is half of 3, and added together makes it 4.5. And there's a fine available of $20,000. Now, you understand that?
Yes, sir.
Now, also, conviction of this charge carries a designation as a Tier 3 sex offender child victim registrant, and that means that you would have to register as a sex offender once you were released from custody for the rest of your life, and be required to report and verify every 90 days and other conditions, which I won't go over until it's decided whether or not you plead guilty. But you understand that there would be that requirement and that consequence of a conviction in this case.
Yes, sir.
Okay. Now, Mr. Salyer, you're not charged with the violation under 2907-2A2 current. It's under A1 in 2 charges. Under the law, no defendant is required to appear before this court for a felony until that charge has been considered by the grand jury of the county and an indictment returned. Now, the grand jury consists of 9 people from live in this county that are selected for service for the grand jury during the term, which is usually about 3 months. And they meet at least monthly or as often as necessary to hear evidence presented about allegations of crime that have supposedly been committed in this county. The grand jury doesn't decide whether someone's guilty or not guilty. They simply decide whether or not there's enough evidence at that point to justify that the case should come before the court for trial. And therefore, it's not required that all 9 agree on the indictment. Only 7 of 9 have to agree. If less than 7 agree, then there is no indictment, and that's the end of that charge. At that point, it could be represented, but it would not be any charge at that time. But if 7 or more indict, then you're served with the indictment, brought before the court as you were originally in this case, and arraigned, and an attorney is appointed. Then the matter is set for trial. There's a scheduling order issued for different pre-trial hearings and opportunity for your client or for your attorney to file motions and to ask for discovery. Now, in this case, it's not changing the facts. It's not a different incident. It's the same incident, but they're saying it's a different form of offense as opposed to what you're charged with. So, yeah, he's already done all that work. But there is a provision under the law that a person can waive or give up the right to have their matter considered by the grand jury, and instead agree to proceed by what's called a bill of information. The grand jury returns an indictment, and 7 of 9 agree there's enough evidence. A bill of information essentially reads the exact same as an indictment, except that it's not considered by the grand jury. Instead, it's simply filed by the prosecutor's office and signed by the prosecutor or one of the assistants, and alleges that's the crime. And what you're doing is, if you agree to that, it means that's the charge you agree you're going to face without action by the grand jury. And the charge that I have in front of me, a bill of information, as I mentioned earlier, and that bill of information reads, I, Anna P. Collins, Montana prosecuting attorney, or over assistants, Molly Holding, James Rader, and King, says by way of information that during the period of January 1, 2019, continuing through June 1, 2019, in Highland County, Ohio, we did engage in sexual conduct with a person identified by the initials TS, and that we purposely compelled TS to submit by force or threat of force in violation of ORC section 2907.02A2 grade, a felony in the first grade against the peace of the state of Ohio. So that's the charge that is proposed that you face. And again, until the grand jury indicts you on that case, you are not required to come to court. But I do also have here, this title, a waiver of prosecution by indictment with your name and case number on it. And it reads, and I, Garrison Michael Salyer, having been informed by the court of all my constitutional rights and my right to be prosecuted by way of indictment and being represented by J.D. Wagner, attorney at law, Hillsborough, Ohio, do hereby freely and voluntarily waive prosecution by indictment and agree to proceed in this matter by bill of information. And that's dated 7/13/2021, and I see a signature, looks like Garrison Salyer and Mr. Wagner's signature. So you signed this agreement as well. Have you signed this document as well, back when you signed the plea agreement?
Yes, sir.
Right. And you understood that by signing this document, you're agreeing to give up the right to have your case considered by the grand jury and agreeing to proceed with the bill of information instead of the indictment.
Yes, sir.
Okay. All right, the record reflecting that he's had a copy of this bill of information for some time, way more than 24 hours.
Yes.
Okay, thank you. All right. Now, do you have any questions about that you understand you're giving up the right to go forward on that case?
I do understand, and I have no questions, Your Honor.
All right, thank you. Now, this agreement states that you're going to withdraw if you're not guilty, plead guilty. But before I get to that point, we do have this matter set for tomorrow, so I'm assuming that the agreement to proceed is based upon the withdrawal of the motion, use style of motion suppressed, or I think that's a little more accurately described as motion eliminate, which if granted could very possibly result in dismissal of the charge. So Mr. Wagner, have you discussed that with your client? Tell the court what the reason for that withdrawal is?
I have, Your Honor, I guess the full history or chronological setting this would be best. The original motion was filed again challenging corpus electi within our part that we were attacking in this case. We were prepared to go to trial or suppress at the hearing a couple weeks ago. That was protocol to allow me some additional research. In the interim time period, at no fault of the state, Your Honor, around July 12th, some information came in through discovery, through the main discovery packet. This case led its way to us through my client making statements to a counselor at the Talbot House. Those statements led to Children's Services being involved, Children's Services to Officer Kelly, Hillsborough PD, where we find ourselves here today. The notes from the counselor showed up, again, from all the state. We got hold of these on July 12th, state forwarded to me. The issue became then to me what statements he made within the counselor's notes that could implicate him in this case. All these statements did is solidify the statement he gave the officer, but there was also additional statements that gave me caution, Your Honor, because my reading of the corpus electi and the cases that followed the Miranda original case, all the state had to prove is some element of the crime being circumstantial at best. As those cases progressed, since I looked at the 1916 Miranda case when it was, up until we sit here today, before the district has been pretty strong, at least from my opinion as a defense attorney, is any circumstantial evidence, however slight, jumps the hurdle for the state. Some of those cases speak about defendant's propensity of prior acts, of other statements they've made, how the children have acted, pediatricians' notes, things of that nature. Taking that all into accord and reading through the July 12th notes, it was my position, I went out to speak with Garrison, I think yesterday, preparing for tomorrow. We reviewed those notes prior to that, but I gave you my honest opinion that I thought originally my motion had great weight, and I thought we had a fighting shot. That weighing in his decision-making process, I thought we had a long shot. It may not prevail based upon my reading of the new evidence. I also looked at, were those privileged information? Was what he gave to the counsel privileged and not admissible? Through statute and case law and mandated reporting, it was my position there was no way I could keep those out, at least with the suppression hearing, to give the court the evidence to tip the scale, to say there was at least circumstantial evidence to go forward. Now, yet a jury could decide, but I think this state, my position, would jump my court with the left eye argument. Speaking with Garrison, and I will say this, he's very articulate, he understands the process, he seems very educated. He agreed with me. I did tell him I would ask him on the record here today if this was his known voluntary decision to withdraw that motion and go forward with what the court has before it. It's my understanding, and Garrison, please correct me if I'm wrong, this is your voluntary decision, correct?
Yes, sir.
Even through my advice, and I would advise you to still roll the dice with this, take it forward, appellate process. You're not wanting to go forward on that. You are electing to have it based on my advice, meaning to withdraw the motion, correct?
That's correct.
And you're asking the court to accept that and go forward with the sentencing and the plea agreement as we sit here today.
Yes, sir.
That's basically what we got today here, Your Honor. Again, put in a lot of time with the research, code sections. I think the linchpin of this was, did those statements from the Talbot House Council come in? In my opinion, I had a tough road to hoe to keep those out. I thought they came in. Therefore, I thought that would have given the court at least enough to let the state move forward to the jury trial. That's our decision on this case.
Okay. We'll make a note that I agree with your analysis regarding the statements of counsel because they are mandated recorded. So that is a statutory exception to the privilege. A person could be required to report and not be required to testify. I would agree with your analysis of the law regarding the district. I know this came up in the State versus James Carver trial a couple of years ago, murder case, where the same issue arose in connection with bringing charge. Although the issue that was whether or not the victim was substantially impaired. And through my research, I found that there's a lot of change in the law on the corpus electi in the last, I hate to say it, 40 years, but actually 46 years. I know there was a case out of Claremont County back in the late 70s, also, where a person walked in on the street and confessed to a murder to the sheriff's department, led them to the scene where the child had been buried for several years. They knew the child was missing, but that was all. The body was autopsied, and the board did not establish death. And that was all they had. And so they had a dead body with no possible cause, not even the possibility. The coroner just said the body was so deteriorated that they could not analyze and make any conclusions at all. And so under that basis, that conviction was reversed because the only evidence they had was a confession. In this case, and I would say that my understanding is confession in that context means to law enforcement. And therefore, if there are admissions against interest made to non-law enforcement officers, such as a reporter in this case, that evidence could be used to substantiate corpus electi to this degree necessary, and to allow the statements that are made to law enforcement in this case to be admitted. So I just put that on the record to say that I agree with your analysis, Mr. White. Now, again, Mr. Salyer, what you could do is, even though I tend to agree with your attorney, if he went ahead and pursued this, then if I allowed the case to go forward, you were convicted of the one or two charges in the indictment, you could appeal the ruling. And if the Court of Appeals agreed, then the case would be thrown out. But, our Court of Appeals tends to, determine or decide on the idea that it doesn't take a lot. But again, this might be a case where you might get change your view. But that would be the gamble that you'd be going through. Of course, in those two cases, you have potential for a sentence that could go up to life. There's a minimum sentence, but it could be up to life. And so basically what you're doing is saying, okay, I'm deciding that I'm not going to take that risk and try to win this case on appeal. Instead, I'm going to go ahead and plead guilty to a different charge that carries a much less sentence, with a maximum of 16 and a half as opposed to the cost of life. So is that how you look at this?
Yes, sir.
And is that your decision that that's what you want to do? And basically give up the idea that you may have a shot, a reversal on appeal if you're convicted of whatever cases?
Yes, sir.
In exchange for getting a certain deal and clear what you are facing in this case now.
Yes, sir.
Okay. You know, you've been threatened or forced in any way to do that?
No, sir.
Okay. All right. Now, under the law, as I indicated to you previously, the minimum sentence for the plea guilty to this would be 3 years, and the maximum in that case then, for if the DRC wants to keep it longer, would be 4.5. The maximum would be 11 years set by the judge, and an additional 5.5 added on by DRC for 16.5. Whatever sentence is to be imposed, because it is mandatory, understand that pleading guilty, you have to be sentenced to prison, whatever sentence I say you get, you have to serve that at least, and then possibly 50% more. You understand that?
Yes, sir.
Once you complete prison term, then the law says that you must be supervised under post-release control by the adult parole authority for a period of 5 years. They will set the terms of that supervision, and the parole officer will supervise you. And if during that period of time that you are under post-release control, again, that's 5 full years, it can't be reduced. If you are found to have violated any of those conditions by the APA, not fully, and so you return to your prison, even though you served the entire prison term under the sentence of court, for an additional period of up to 9 months for any single violation. But there is a cap or limit on cap of whatever prison term is imposed for all violations, with one exception. If you commit a new felony while under post-release control supervision in this case, then in addition to whatever sentence the judge in that new case can impose, that judge will also sentence you in this case to an additional period of 1 year, whatever time is left on the 5 years of post-release control, whichever is greater, for committing that offense while under post-release control in this case. And if that happens, that has to be served consecutively the sentence in the case. You understand that?
Yes, sir.
Now, as I explained earlier, this agreement does have a provision about control of probation, but it's been stricken out. Again, you understand, probation or control is not possible.
Yes, sir.
Right? Now, I read the charge to you in the bill of information a minute ago, well, a few minutes ago now. You remember that?
Yes.
And do you understand what it is you're being accused of having done, and when the state said you did it, when, where, and how they let you did it in that charge?
Yes, sir.
And you understand the possible penalties for that charge?
Yes.
Discuss the nature of that charge, the evidence of the case, possible legal issues of the case, possible defenses you try to raise in trial, and possible outcomes of a trial with your attorney.
Yes, sir.
And are you satisfied with Mr. Wagner's advice and confidence in this matter?
Yes, Your Honor.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Are you taking any prescription drugs?
Yes, sir.
What do you think?
Lisinopril and Metropol.
Either of those interfering with your ability to understand what's happening here today and to communicate your thoughts and read whatever is presented to you?
No, sir.
You understand?
Yes, sir.
Has that affected you at all during the time you've been in jail?
No, sir.
And when you signed this agreement, did it affect you in any way?
No, sir.
Okay. Now, on page 2 at the bottom of this plea agreement, there are 3 sentences, well, pretty long, that are printed in bold and underlined, so I'll read those to you at this time. Defendant shall enter a plea guilty to the bill of information. State defense jointly recommend 10 years incarceration. State will dismiss other charges outlined in the indictment. Defendant shall be a Tier 3 registered sex offender, which I claim to use a lifetime registration. Now, is that your understanding of the agreement?
Yes, sir.
Does anyone promise you anything other than that in case you plead guilty here today?
No, sir.
And the matter of sentencing is up to the judge, so even though there's recommendation of 10 years, if I decide that you should get 11 or a number less than that, I can do that. You understand that?
Yes, sir.
Okay. And you understand you could also be applying those.
Yes.
Now, do you hold any license or certificate from any state agency for any kind of profession or occupation?
No, sir.
Then you have certain constitutional rights you must understand. Work and accept a plea here. First of all, you do have a right to have counsel. Mr. Wagner's been your attorney in this case sometime. I did appoint him simply to work the case out, but provide whatever defense might be available to you under the law that you wish to provide. Please explain what, one motion you raised to do that. Now, if you decide you don't want to plead guilty to this charge, and that's fine, if you do that, they'll still defend you. We'll hear the motion, and the court will make a ruling, and if it's overruled, we'll have a trial, and he'll defend you in trial if that's what you want. You understand that?
Yes, sir.
And now, under the Constitution, Mr. Sally, you have the right to have a jury trial in this matter, in which 12 people will be selected from a group of citizens that live in this county that are summoned for jury duty on their trial date. And 12 people will be selected for that jury. After those 12 are selected, the evidence will be presented. They'd be instructed on the law. They would then decide by unanimous verdict, 12 have to agree, on whether or not the state proved your guilt on the charge. Now, if you decided you didn't want to have a jury trial, but you did not want to plead guilty, you can waive in writing, which means, in legal sense, to give up your right to have a jury trial on this charge, and then you would have what's called a court or bench trial. And that means that instead of the jury hearing the evidence, it would be the judge who hear the evidence. The judge will apply the law. The judge will decide whether or not the state proves your guilt by proof beyond a reasonable doubt. Do you understand that?
Yes, sir.
Right now, under the Constitution, you have a right to confront witnesses against you in this case and cross-examine them through your attorney. So the witnesses against you would have to come into court, testify in public in front of you, your attorney, and anyone else who's present. After the prosecutor asks those folks questions, then your attorney could ask questions. That's what is called cross-examination. And the purpose of that is to try to bring out evidence that would help your side of the case. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to use the power of this court to compel or force witnesses to come to court to testify for you, just like the state. So if you have witnesses you're uncertain are going to come in voluntarily at your request, a subpoena is issued, and that is a court order. That forces those people that are named in the subpoena to come to court to testify for you, even though they don't want to be here, which is the same way the state's witnesses are required to come to court. You understand that?
Yes, sir.
Under the Constitution, you have the privilege of self-incrimination in this case, Mr. Salyer, which means you cannot be forced to give evidence in this matter at any time, including trial. Now, if you can, but you're not required to. But whether you, and if you decide, well, first of all, let me back up. No one can make you testify. The prosecutor can't and the judge can't. It is your decision totally. And if you decide not to testify, no one is allowed to talk about that, and no one's even allowed to comment about it at any time in the case, including trial, with one exception. If there is a jury trial and you do not testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a presumption of innocence. What that means is that you're presumed innocent of this charge until proven guilty by the state of Ohio on every essential element of the offense charged. So the burden of proof isn't on you to prove that you're not guilty of this charge. The burden is upon the state to prove that you are. And they must, and you're not even required to present evidence in your own defense in the trial. You can, but you're not required to. Whether you present any evidence or not, the burden of proof will remain upon the state. Prove your guilt on every essential element of the offense charged by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, Your Honor.
Right, now originally you entered a plea of not guilty in the indictment, and the plea of not guilty denies the allegations in the indictment or of information, and denies you committed any offense. That plea exercises and invokes all of the rights I have described for you here this morning. Now, if you plead guilty to the bill of information, because you haven't entered a plea to that yet at all, you could, plead not guilty. But if you plead guilty, then that plea is the opposite of a not guilty plea. Guilty plea admits the allegations in the indictment, admits that they're a crime, and that you committed that crime. And that plea gives up all of the rights that I have just described for you here this morning, except your right to have a jury trial, because you always have a right to have your right to have an attorney. Because you always have a right to have an attorney no matter what you plead. But with that exception, a plea of guilty would waive or give up your right to have a jury or court trial. It would waive or give up your right to confront witnesses against you and have your attorney cross-examine them in open court. It would waive or give up your right to use the power of the court to compel or force witnesses to come to court and testify for you, the same extent. mistake. You would waive or give up your privilege against self-incrimination because you're the one that's saying you're guilty, and that's what's used to find you guilty. It would waive or give up your presumption of innocence because if you say you're guilty, then the state doesn't have to present evidence that you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives or gives up any right to file an appeal that you think you should have had for any alleged violation of your rights or any errors in this proceeding, including motion to withdraw, that may have occurred, in your opinion, up to this point in the case. Now, if I give you a maximum sentence, or under the limited circumstances, you might be able to file an appeal, but it would have to be filed within 30 days of the entry of sentencing being filed. Now, do you understand all of that?
Yes, Your Honor.
And are you a U.S. citizen?
Excuse me?
Are you a U.S. citizen?
Yes, sir.
Okay. Now, before we go any further, going back to Marcy's law, did the victim or representative victim been notified of this hearing and the plea agreement?
The victim is 3 years old, currently in the temporary custody of the agency.
Okay.
The agency's legal counsel.
Right. Okay. Now, Mr. Snyder, you have any questions about the bill of information or the waiver of indictment process that we've gone through in this matter?
No, sir.
You understand that?
Yes, sir.
Questions about that charge and the bill of information or the possible penalties?
No, sir.
You understand?
Yes, sir.
And again, you understand the designation of the sex offender required Tier 3 lifetime in this state.
Yes, sir.
Have any questions about the constitutional rights of explained?
No, sir.
You understand those?
Yes, sir.
Do you have any questions about the plea of guilty, what it means, and what will happen if you enter that plea here today?
No, sir.
And again, you understand you're giving up the right to challenge the indictment or the statements of the corpus electi that we discussed, Mr. Wagner went through a few minutes ago, and I made some comments on. You understand that?
Yes, sir.
Okay. Is there anything you'd like to say, Mr. Wagner, about before we go any further?
No, sir.
Any questions about anything that I was explaining to you here today or anything that's occurred so far?
No, sir.
Understand?
Yes, sir.
All right, then is it your decision to go forward with this bill, with this plea agreement that you signed? It looks like back on the 13th of July, along with the bill of information waiver. Is it your agreement to waive indictment, plead guilty to the bill of information pursuant to the terms of the plea agreement that we've gone over here this morning?
Yes, sir.
All right. And as to the charge and the bill of information, which alleges that on or about the period of January 1, 2019, continuing through June 1, 2019 in Highland County, Ohio, you did engage in sexual conduct with TS, and the said Garrison Michael Salyer personally held TS to submit by force and threat force, violation of ORC section .907.02A2, rape and felony in first degree against the peace and dignity of the state of Ohio. A first degree felony carrying a minimum sentence to be decided by the judge between 3 and 11 years, with the maximum being half of whatever number the judge picks that can be added by Department of Rehabilitation and Corrections to the sentence, meaning the possible maximum would be 16.5 years. Fine above, and plus a designation as a Tier 3 sex offender with lifetime registration requirements, and a fine of up to $20,000. How do you plead?
Guilty.
All right, thank you. Be seated. All right, the court finds that on this day, the court advised all his constitutional rights, made no intelligent voluntary waiver of the same pursuant to criminal 11. Please accepted it and filed. The court will find that the indictment is dismissed based upon the bill of information being filed. And the charges in the indictment are dismissed. And the court will find that he made a no intelligent voluntary waiver of his rights pursuant to criminal 11 after being advised of them by the court. The court accepts the plea, orders it filed, and is found guilty of the charge of rape under 2907.02 A2, a first degree felony. The court will not order a prison investigation given the nature of this offense, stipulated recommendation, and therefore the court will proceed with sentencing for the court. The court also note does not request a prison investigation. King, we have to say,
Only was contained in the plea agreement, Your Honor.
Wagner.
Mayor, we would ask the court to follow the recommendation of the parties. Obviously, this case, the major importance, very severe, very concerning, the situation that went on. If there is a silver lining or any credit to my client, Your Honor, he is the individual who brought this to light, reported it to his wife, counsel made a full confession, police arrived, made a full confession. He's not denied these issues. Sadly enough, I'm not defending misconduct. We see it, sadly enough, in this court. He was a victim. He was a young man. I'm not justifying what he has done, but you know, we hear about it or read about it, or people tell us that victims turn into predators down the road. And when he was a young man, he was preyed upon as well. So I just see that pattern repeating itself. Hopefully there will be a way to stop that sometime in the future, not only for Garrison, but for all individuals. That's where we're at here today.
All right. Mr. Masadi, anything you'd like to say?
Does it?
Well, let me see first.
Okay.
Before I pronounce sentence, I will explain your duties to register as a sex offender or child victim register. Because we are pleading guilty to the charge of rape, you are hereby designated, as a matter of law, a Tier 3 sex offender, child victim offender register. That means you'll be required to register with the sheriff of the county in which you're living, and in other counties, as I'll explain here in a moment, for your lifetime once you're released from prison. And that must be in person, and you will be required to appear at that location every 90 days, not by phone or email or Zoom, but in person. Now, you'll be required to register the sheriff in which you're going to establish residency within 3 days of coming into that county, or if you're temporarily staying there for more than 3 days. And at this point, your anticipated residence would be in Adams County, and so that would be at the Adams County Sheriff's Office on 110 West Main Street in West Union, Ohio. Now, you're also required to register in person with the sheriff of any county in which you establish a place of education. You must do that immediately upon going into that county for that purpose. So, say you live in Adams County, you go over to the Southern State Ranch in Brown County, you have to register with the sheriff of that county same day that you become a student there. You are also required to register with the sheriff in any county in which you are employed if you are working there for more than 3 days in a row, or 14 days total in one calendar year. Now, what that means is that you could be required to register in as many as 3 places: where you're living, where you're going to a place of education, and where you're employed. For purposes of employment, that also includes community service or volunteer service that you might be doing under the circumstances. Now, if you must also report any change in your information. So if you're not going to be at your residence where you're registered for 7 days or more, whether go visit family or vacation, or perhaps you're hospitalized, you're in a rehabilitation facility or something, you must report to the sheriff where you live, where you're going to be, what the address is, and how long you expect to be there. You're also required to periodically verify your residence and place of employment. Again, as I said, that has to be every 90 days as far as register your sex offender. If you're in a different state, you're also required to register in that state with either the sheriff, or if there's a different public office that is charged with maintaining sex offender registration, then you have to register in that state. And again, if you're out of state, say you're going to Kentucky for work or educational purposes, you have to register there. For work, it'd be if you're there for more than 3 days in a work row, or 14 days total in a year. And you must verify every 90 days, but no earlier than 10 days before your verification date. So that means that if you go in anytime between the 80 and 90 day period from the last registration, no earlier and no later. If you change your residence, you have to provide a written notice of that change to the sheriff of your current registration of residence, as well as to the sheriff in the county in which you're going to reside or establish place of residence, and in advance. And if it's a place of education, you have to do that at least 20 days prior to that change, and no later than 3 days after change in employment. Again, remember, you can't be in a county for up to 3 days before you have to report that, or 14 in a calendar year. If at any time you don't have a fixed address, in other words, you're homeless, you have to provide a detailed description of the place or places you will be staying, and then no later than the end of the first business day, immediately following day, you obtain an address or fixed address, and must register that address with the sheriff. Now, under federal law, you're required to report, if you have a passport, you're required to report any plan to travel internationally at least 21 days before that, and failure to do so could result in you being prosecuted for state and federal. Now, you're also required to provide your information about your email, internet identifiers, telephone numbers, vehicles used by you. And if you have any change of that, you must report those changes within 3 days. Now, if you fail to perform any of these obligations, again, it's going to be a lifetime registration obligation. So the rest of your life, if you ever violate any of these conditions, by failing to register, or failing to verify, or reporting any changes as required, then you could be subject to criminal prosecution under Chapter 2950 of the Ohio Code, and those offenses would be a felony. It would depend upon what you did as to what the degree was. Okay, then you can make 3 copies for all right. Now, anything else either council like to say, since you have a few minutes to think about explaining that?
Something to say, Your Honor.
The bailiff's going to get copies of that. Oh, and you need to have him sign it for me. Hey, tell Ben I need to have him sign it for me. Gotta have it so. All right, the record collector bailiff is going to present that to Mr. White for him to review. There's a place for you to sign there, Mr. Salyer, which acknowledges that you've had that explained to you. You'll get a copy of that after you sign it, and Mr. Reynolds bailiff makes copies. All right. Now, regarding sentencing, anything further, Mr. White? Anything else you want to say, Mr. Salyer?
No, sir.
Well, these are very, the charge is extremely serious in original indictment. As indicated by the possible sentence of a lifetime. Young victims of these cases, make no sense to the court. A lot of people think it should be punishable by death. Again, if that were the law, that I wouldn't see anything wrong with that, but it is not the law. There are certainly good reasons in the record as to why this is the agreement, because of that legal issue, and the state agreed to have a fixed charge, which is a substantial penalty. And you're making the decision rather than take the gamble of winning an appeal, conviction for a life sentence, taking this decision, and making this decision. And so, it does state the expense of the trial. Victim was most likely to get the testimony. And so I've never had a pretty qualified testimony. I don't expect to see that happen. But in any event, given those circumstances, I understand the reason for the plea, and it's the judgment of the court that D and are hereby sentenced to the correction section 7 at Ohio for a period of 10 years. Now that would be and that is a mandatory sentence. You have to serve every day of that, subject to any jail time credit. And that is the minimum mandatory sentence. And a maximum sentence could be up to 15 years, because as I explained to you earlier, our corrections could, rehabilitation corrections, DRC, could decide that you should serve an additional period of up to 5 more years. So that means that the sentence could be as much as 15 years, but 10 years is mandatory as I would. Now, you're also notified that on completion of the prison term, whether it be 10 years or more, depending upon the Department of Corrections decision, you will be supervised as a sex offender for a period of 5 years by the adult parole board on the terms and conditions that they will set forth. The judge has no involvement in that. And if they decide that you may fail to comply with those conditions, then they can return you to prison to make you serve an additional period, even though it's maximum provided by law, up to 9 months for a single violation. And if there's more than one violation, it could be up to a cap of half of prison term, as ordered by the court or determined by the Department of Corrections. However, if you commit a new felony during that time you're being supervised, then as a matter of law, the judge in that case, in addition to whatever penalty could be imposed for that violation, would also sentence you in this case for committing that new felony while under post-release control supervision to an additional period of 1 year, or whatever time is left on the 5 years of post-release control, whichever is greater. If that occurred, that would have to be served to the second release sentence in the case. You're also ordered to pay the court costs for the judge granted an execution order. If you fail to do that, the clerk can collect that through various means, including levy on bank accounts, wages, earnings, or other assets that you may have. If that doesn't collect it, then once you get out of prison, not while you're in prison, once you're completed, you could perform community service to get credit against that, and you're given an hourly rate set by the judge. That time won't with me, be long retired, and then which hour you work, lose your judgment until it's paid for. For the sheriff, as of June 30th, he had 70 days. Your arrest date was April 27th. Okay, so an additional 31 days in July plus 4 today, additional 35 days, so it gives 105 days of jail time credit against that sentence. Is there anything further from counsel?
No, Your Honor.
Your man in custody, Mr. All right, Mr. Morrison.
Approve, sir.
Thanks.
And I'll say,
All right, this is case number 21 CR 104, State of Ohio versus Junior Lewis Morrison. President of the State's Prosecutor, Assistant Prosecutor King, President of the Defendant, Attorney Jacob White. Are you Junior Lewis Morrison?
Yes.
State custody. Mr. Morrison is charged in a two-count indictment with illegal conveyance of drugs of abuse on the grounds of a specified governmental facility, third-degree felony, and aggravated possession of methamphetamine, a fifth-degree felony. And the matter is set for pre-trial, for final pre-trial on August 11th, next week, and then also set for trial on August 26th. Now, court has received a plea of guilty for and set the matter for a plea hearing after being notified by the parties that there had been an agreement reached. And I have this 3-page document in front of me, Mr. Morrison, with your case number and your name on it, plea guilty. Says you're going to plead guilty to count 1. On page 3, there are signature lines, and near the very top of the page, there's a sentence that says, "I enter this plea voluntarily." Underneath there's a line with an X on it, and it looks like Junior Morrison is the signature. Is that your signature I'm looking at?
Yes.
And that's how you sign your name. You don't use your full name when you sign. Okay. And when did you sign this agreement, Mr. Morrison?
This morning.
Okay. And did you go over this with your attorney before you signed it?
Yes.
He explained everything to you?
Yes.
Did you understand that this is agreement to plead guilty, which means there won't be a trial? The next step in your case will be a sentencing hearing?
Yes.
When you came up here today, is this what you knew was going to happen?
Yes.
You're not surprised by this development?
No.
You knew this was being requested to be sent today instead of waiting next week?
Yes.
Got enough time to fully consider this matter before making this decision?
Yes.
And are you entering into the agreement to plead guilty voluntarily?
Yes.
Right now, the agreement states on page 1 that you're going to withdraw your not guilty plea, plead guilty to count 1. It's illegal conveyance of drugs of abuse to the grounds of a specified governmental facility, violation of section 21.36A2 of the Ohio Vice Code, a third-degree felony. Which states you understand the maximum penalty for that could be 36 months in prison. If there's a prison term imposed, as minimum is 9 months. And there's certain levels in between. There's 9, 12, and then every 6 months after that, up to 36 months. There's a fine available of up to $10,000. And that's it. You understand that?
Yes.
Are you facing any, this one doesn't carry a license suspension. I was thinking it'd been optional, not mandatory.
I didn't believe the conveyance did.
Okay, I know there's some strange exceptions to that law, but it doesn't matter because I don't do it. It's not mandatory, I'm not supposed to anyway, so we'll worry about it. All right. Are you facing any felony charges anywhere else?
No.
Are you currently on probation, community control, parole, or police control from any jurisdiction?
No.
Now, under the law, if you are convicted of this offense, once you complete the prison term that's imposed by the court, if one is, I'm not saying it will be, but if you should serve a prison term, then once you complete that term, it is possible adult parole authority will put you under police control supervision by a parole officer in the term that they set. They don't have to, it's optional, so they'll make the decision, not the judge. The judge has no involvement. If they decide you should be under post-release control supervision, then you'll be supervised on the terms that they set by a parole officer and they determine. If you fail to comply, then they can return you to prison, even though you served the entire term set by the judge for a period of up to 9 months for any single offense, but up to half of whatever prison term was ordered to be served for all offenses or all violations. If you commit a new felony while you're on post-release control supervision, in this case, then in addition to whatever sentence to be imposed for the violation of the new case, that judge could also sentence you for committing that violation while under post-release control, in this case, to an additional period of 1 year, whatever time is up on the 3 years of post-release control, whichever is greater. And if that occurred, then it would have to be served consecutively to the sentence in the new case. Do you understand that?
Yes.
Right now, under the law, I'm not required to sentence you to prison for this offense. I can impose what are called non-prison or community control sanctions. What that means is that instead of being sentenced to prison, you could be put under the supervision of a probation officer for a period of up to 5 years under the term set by the court. And if during that period of time the probation department felt that you were not complying, they could return you to prison. Or I'm sorry, they could file an allegation of that with the court and then the court would conduct a hearing, and then you would have an attorney to represent you in that hearing, you could have. And then if the outcome of the hearing at that time was that you violated, then the court could revoke your community control, and then you could be sentenced to prison for 36 months and fined $10,000. You understand that?
Yes.
Now, the charge alleges that in count one, that on or about December 28, 2020, Huntington County, Ohio, you did knowingly convey or attempt to convey onto the grounds of a detention facility, the Huntington County Justice Center, and there's some other language in there that doesn't apply, a drug of abuse as defined in ORC 3719.011, to wit, amphetamine, in violation of section 2921.36A2. And that's the charge of illegal conveyance of drugs of abuse to the grounds of a specified governmental facility. Third degree felony with penalties I just described, 36 months in prison and a $10,000 fine. Now, Mr. Morrison, do you understand what it is you're charged with, what the state said you did, when or how they let you did it?
Yes.
You understand the possible penalties?
Yes.
We've discussed the nature of this charge, the evidence in the case, possible legal issues in the case, and possible offenses you might try to raise in trial, possible outcomes of a trial with your attorney.
Yes.
Are you satisfied with his advice and confidence in this matter?
Yes.
Are you under the influence of any types of drugs or alcohol at this time?
No.
Are you taking any prescription drugs?
No.
Has anyone threatened you to get you to plead guilty here today?
No.
Now, on page 2, there are 3 lines that are printed in bold print and underlined, and I will read those at this time. Defendant shall enter a plea of guilty to count 1 of the indictment. State will dismiss count 2 of the indictment. State defense jointly recommend community control and residential substance abuse treatment. Is that your understanding of the agreement?
Yes.
Anyone promise you anything other than that to get you to plead guilty?
No.
Under the law, the matter of sentence is up to the judge, not to the parties. So even though there's a recommendation from both the prosecutor and you and your attorney that you should get community control, I could decide that's not an appropriate sentence and sentence you to between 9 and 36 months in the increments provided by law in prison, and also fine you $10,000, but I think that's the correct sentence. Do you understand that?
Yes.
Do you hold any license or certificate from any state agency or board, any kind of an occupation or profession?
No.
State of Ohio.
No.
Now, you have certain constitutional rights, you must understand. First of all, you have right to counsel. We're appointing Mr. Wagner to represent you in this matter. That wasn't simply to work the case out, but to provide any defense that could be available to you under the law that you wish to provide. So if you decide that you do not want to plead guilty, then he will continue to represent you, defend you, including a trial, if that's what you want. You understand that?
Yes.
Under the Constitution, Mr. Morrison, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that are summoned for jury duty from this county on your trial date. After those 12 are selected, the evidence will be presented, and they'd be instructed on the law by the judge, and then that jury would decide by unanimous verdict, meaning all 12 would have to agree on whether the state proved your guilt of the charge. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up the right to have a jury trial, and in that case, you would have what's called a court or bench trial, meaning that instead of a jury hearing the evidence, the judge would be the one who hears the evidence, applies the law, and decides whether or not the state proved your guilt back, proved beyond a reasonable doubt. Do you understand that?
Yes.
In the Constitution, you have a right to confront witnesses against you and to cross-examine them through your attorney. That means that the witnesses against you have to come in court, testify in front of you, your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney can ask questions. That's called cross-examination. And the purpose of that is to try to bring out evidence that might help your side of the case. Do you understand that?
Yes.
Under the Constitution, you have the right to use the power of this court to compel the court's witnesses to come into court to testify for you, just like the state. So if you're not certain the witnesses you want to testify are going to come to court voluntarily, request court issues that court order is called a subpoena, and that forces them, and the court will be available to testify for you if that's what you want, even though they don't want to be here, which is the same way the state's witnesses are required to come to court. Do you understand that?
Yes.
All right? Now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence or to testify against yourself in these proceedings at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, you make that decision. And if you decide not to testify, the fact that you did not testify cannot be used against you in any way, by any person, at any time in the proceedings. And in fact, no one's even allowed to talk about it, with one exception. There's a jury trial, you don't testify. The judge does instruct the jury that because that is your constitutional right, they cannot consider it for any purpose. Do you understand that?
Yes.
Now, under the Constitution, Mr. Morrison, you're presumed innocent of this charge until proven guilty by the state of Ohio by proof beyond a reasonable doubt on all the essential elements of the charge. What that means is that the burden isn't on you to try to prove you're not guilty simply because you've been accused by being indicted. In fact, under the law, you don't have to present any evidence at all in your defense. You may, but you're not required to, including trial. But whether you present any evidence at the trial or not, the burden will remain upon the state of Ohio to prove your guilt or prove beyond reasonable doubt every essential element of the offense charge, which is the highest burden of proof that's known under the law. You understand that?
Yes.
Originally entered a plea of not guilty, Mr. Morrison was denied the allegations in the indictment, denied you committed any crime, and had exercised or invoked all the rights I just described. If you change your plea today from not guilty to guilty, count one, that plea will be the opposite of a not guilty plea. Guilty plea will admit the allegations in the indictment, count one, admit that there are crimes, that you committed that crime. And that plea waives or gives up all the rights that I've just described, except your right to have an attorney, because you always have a right to have an attorney no matter what your plea may be. But with that exception, your plea of guilty would waive or give up your right to a jury or court trial, would waive or give up your right to confront witnesses against you and cross-examine your attorney, waive or give up your right to use the power of the court to compel or force witnesses to testify in the same state, waive or give up your privilege against self-incrimination, because you're saying you're guilty, and that's what usually finds you guilty. Waives up your presumption of innocence, because if you say you're guilty, the state doesn't have to prove you guilty. It also subjects you to being sentenced immediately by the court, if I think that's the right thing to do. And finally, it would waive or give up your right to file an appeal on any alleged violation of your rights you think may have occurred up until this point in the case. Now, if I were to sentence you the maximum sentence or under the circumstances you can file an appeal, it would have to be filed within 30 days of your sentencing entry being filed. You understand all of that?
Yes.
Are you a U.S. citizen?
Yes.
All right, now, do you have any questions about the charge or the possible penalty?
No.
You understand it?
Yes.
Do you have any questions about the plea agreement?
No.
You understand it?
Yes.
Do you understand that, of course, not bound by the sentencing recommendation, probation, or community court?
Yes.
Do you have any questions about any of the constitutional rights I've explained to you?
No.
You understand those?
Yep.
Any questions about the plea of guilty, what it means, what the consequences that will be if you enter here today?
No.
You understand?
Yes.
Is there anything you'd like to speak to Mr. Wagner about before we go any further?
Yeah, could you give me a form for exit program? So copy.
Right.
Referral paper for exit program, so copy.
Yeah, I'll address that, Your Honor. Something that cannot be addressed at this point in time. It's not pertaining to, shall I say,
Yeah,
the
okay.
manner.
Any questions about the plea agreement or anything I've explained to you here this morning? Do you have anything, do you understand everything that's been talked about so far? All right. Then is it your decision, Mr. Morrison, to withdraw your not guilty plea, plead guilty to charge and count one as set forth in this plea agreement that you signed that I just went over with you?
Yes.
Okay. Then as to the charge of count one, I'll just read the relevant portion of that since there's some references to other facilities that aren't applicable. And the relevant section reads, on or about December 28, 2020, in Highland County, Ohio, you did knowingly convey or attempt to convey onto the grounds of the detention facility, Highland County Justice Center, a drug abuse as defined in ORC section 3719.011, to wit methamphetamine, violation section 2921.36A2, charge of illegal conveyance of drugs of abuse onto the grounds of a specified governmental facility, violation section 2921.36A2, felony of the third degree, carrying possible prison term between 9 and 36 months, and income provided by law, and a fine of up to $10,000.
You.
Thank you. You can be seated. All right, the court finds on this day in open court, the defendant provides all his constitutional rights, made a knowing and intelligent and voluntary waiver of the same pursuant to Rule 11. Please accept it in order to file. The defendant is found guilty of count one and count two is dismissed. The pre-sentence investigation is ordered. Court order include an assessment for substance use disorder treatment as well as mental health. Bond will be continued. Sentencing hearing will be set for September 1, 9 a.m. All right, is there anything